cause number PD-0330-22, Terry Wayne King II versus the State of Texas.
May it please the court. My name is Victoria Oblon and I represent the state of Texas in this case. This is a standing case in which the defendant bears the burden of proof, not an abandonment case in which the burden is on the state. Mr. King has failed to establish that he had a reasonable expectation of privacy in a truck that he drove for work after he was removed from the truck, and the truck, his employer, regained possession and control of the truck. There are two
Counsel?
yes.
Does he still have a property interest in his phone?
He does have a property interest in his phone, and he has an expectation of privacy in the contents of his
Right.
phone. And that's a very big distinction, and the contents of the phone were searched pursuant to a warrant in this case.
Well, I guess what I'm getting at is that even if I agree with you that the police can go into this car or this truck, and he has no expectation of privacy in the truck, can he still challenge the seizure of his property that's there?
No, once the expectation of privacy in the location is extinguished, then the police can seize items that are in that location. An individual, a defendant, retains an expectation of privacy in contents of items left there, whether it's a cell phone or concealed containers that may be in that location that there's a possessory or property interest in. But the cell phone itself is just like any other article of evidence, piece of clothing, that once the expectation of privacy in the location is forfeited, then the police have the right to seize those items.
Okay, well, I guess that leads me to another question I just want to make clear about. This is not about the propriety of the search. This is only about whether the defendant can challenge the search and whether or not there was an expectation of privacy in the truck.
That is correct.
So we're not looking for exceptions to the warrant requirement. We're looking at just whether or not there's any expectation of privacy in the truck. That's the only,
Yes.
that's it. Okay.
Yes, that is correct. The state conceded at in the trial court that the Oklahoma search warrant had expired at the time of when Mr. Feltman, the owner of the truck, went and retrieved the phone. So we're just looking at the expectation of privacy. And that is actually one of the kind of introductory points that I want to make, is that we are looking at the expectation of privacy in the truck, not the cell phone. And
Did the warrant actually have an expiration date on it?
the pursuant to Oklahoma statute, the warrant, I'm not entirely sure how many days under Oklahoma law, but
Is it in the record? I mean, will we be able to see the actual warrant and see whether there's an expiration date on it?
yes, the warrant is in Reporter's Record, Volume 7, pages 168 through 74, and I believe it is on the warrant.
But even if the warrant expired, that doesn't take away the fact that the police had, presumably because a warrant issued, police had probable cause to go into that vehicle and search it, right?
That is correct. Yes.
So to what degree, if any, does the automobile exception provide a right to go in even in the absence of a warrant?
I think the automobile exception would apply to this case. In California versus Carney, the United States Supreme Court held that mobile homes are subject to the automobile exception, and in this case, there's been argument that because it was a long-haul truck, it was essentially a home on wheels, which would be a mobile home. So the automobile exception would apply. That exception was not relied on in the trial court, so whether it is law applicable to this case, the state has not argued at this time.
Has the state taken any position with regard to whether the owner of the truck who went in to get the phone, whether that person was a state agent at that point because of the request from the police?
We did not argue in any true sense in the trial court or on the Court of Appeals, but given the fact that Mr. Feltman received a phone call from police and was acting on their request, and then he was reimbursed for mailing the phone back, I think the state would see that he was a state actor in that regard.
Counsel, just to reiterate, the automobile exception is an exception to the warrant that can justify a warrantless search. That's different than whether or not there's an expectation of privacy in the area to be searched.
Yes,
Okay.
yes, that is correct. And when we're looking at the expectation of privacy in the location that's searched, as we've clarified, is the truck itself. The proper time to analyze that expectation of privacy is when the search occurred. And in this case, that was days after Mr. King's arrest, when his employer, Mr. Feltman, had already gained control of the vehicle. The Court of Appeals here, in analyzing the factors that this court has laid out in analyzing expectation of privacy, that's the possessory interest in the vehicle, whether they were legitimately in the location, whether they had complete domain and control and right to exclude others, whether they've taken privacy precautions, and putting the location to a private use. The Court of Appeals in this case improperly looked at the time of Mr. King's arrest and even backdated that to when he was driving the vehicle and how he used it as an employee using this truck as a long-haul trucker.
Is this like a utility truck or an 18-wheeler that would have a bed and like a home on wheels?
So the record is really not overly developed in that regard. There are no photos of the truck. There was no testimony regarding the truck. The only thing in the record regarding the type of truck is in the search warrant affidavit. There's a line saying that the truck was, that the police believed the defendant lived out of the truck, that he was a long-haul truck driver, that they believed that he lived over it. So I think it's a reasonable assumption that there was maybe a bed in the truck, something of that sort.
Other than the fact that he might live in it, he didn't own it, did he?
No, he did not own it.
And at the time it was searched, was it something that he was using, or was it back at the normal course of business and the owner just went out and grabbed the phone?
The latter. After the time of the search, Mr. King was incarcerated, and Mr. Feltman, was the owner, and Mr. King's employer had regained possession and control of the truck, and he went out to the truck. And that's, I think, important in this case because, like I said, at the time of the search, Mr. King had really no interest in the truck. As the owner and the employer in this situation, Mr. Feltman had exclusive control and possession of the truck. He could have taken everything out of the truck and thrown it away. He could have reassigned the truck to another driver. He could have done whatever he wanted to with the truck because he was the owner. And that also goes to the fact, in the Court of Appeals opinion, the court noted that really the only thing that deprived Mr. King of his expectation of privacy in the truck was his arrest and incarceration. But that's not true because Mr. Feltman, the owner, had regained possession. He got the truck. There's no, it's not clear in the record, where he had the truck located or what have you, but it is clear that he had control of it. He was able to access it. He went in the truck to regain the cell phone, retrieve the cell phone. And so it's clear that he had control and possession.
Is there a standing issue raised by the state that he didn't even have the right to challenge the search of the vehicle?
Yes, okay. yes. That was standing was the primary issue in the trial court and again at the Court of Appeals.
So, counsel, was Mr. King, had he been terminated at some point? I mean, like officially terminated from his employment after his arrest?
There's no evidence of that he had been terminated.
Okay.
No.
And so, I mean, you're not contending that he didn't have standing at the time of the initial search. You're not saying he didn't have standing.
Correct.
Well, I mean, sort of explain to me then, at what point does he lose standing? Because obviously they don't know about the phone. So they only learned about the phone during the first search when he had standing. And then it's only later on when I guess the detective says, oh, whoops, we have a photo of a phone, but we don't actually have the phone itself. So when do you think he lost his standing?
I think when his employer regained possession and control of the vehicle. When the search warrant that issued for the first search of the truck, Mr. King was arrested from the vehicle, taken into custody, and they obtained a search warrant for the truck that day. The truck was still at the truck stop that Mr. King was arrested at when that first search was initiated. And then Mr. Feltman went to retrieve the phone days later. We do not have the specific date that Mr. Feltman went to retrieve the phone, but sometime during that period, Mr. Feltman regained control and possession of the vehicle.
So pretend for a second that Mr. King, he's arrested and for whatever scenario, bonds out, gets a PR bond, immediately goes back to the truck stop, and Mr. Feltman's there and says, hey, you've been arrested, I'm taking the truck, and Mr. King says, wait, whoa, let me get my stuff. Does he have an expectation of privacy at that point?
I think that he would, yes. I think that those are different facts than the facts that we have here. And I really think that it is Mr. Feltman, regaining possession and control. And, that this follows with this court's case law with guests in a host home or a hotel occupant in a hotel. In both of those situations, in Granados, which is the guest in a host home, this court really focused on the host's ability to control the premises, ability to use, and their permission that they're granting their guests in that home. Similarly, in Tillman versus State, which is the hotel situation, this court noted that it was the affirmative steps of the hotel in the eviction process that extinguished the expectation of privacy in that location, and that's very similar to what we have here. The
Counsel,
employer.
What was was seized in the Tillman case?
In the Tillman case, it was nothing was seized. Excuse me, let me go back. The police entered the motel room or hotel room pursuant during the eviction process. Right. While the individuals there were collecting their belongings, the police observed drug paraphernalia in plain view, and the drugs were then seized.
And drug paraphernalia is contraband?
Yes.
Okay.
Yes. So it was contraband that was seized.
Yeah. Okay.
But very similar to those two situations, someone with a greater right to the location, someone who can dictate the permission of the location being used in that location, came in, took affirmative steps to regain control, possession, ability to use that location. And that's what Mr. Feltman as the employer did, and that's what extinguished Mr. King's expectation of
Does
privacy.
it make any difference if that regaining of the property was accomplished by virtue of the police asking the owner to do that, right? Because here you have a phone call, I imagine, saying, hey, can you go out to that truck? I think the truck, correct me if I'm wrong about this, is still at the truck stop where the arrest occurred. And so they go there. They hadn't had any interest in going there before the phone call. And then the police make the phone call, and they show up at the location and go into the truck. All of that is done at the behest of the police. Does that make any difference?
Well, just to kind of clarify the record there, the first search, at the time of the first search that was pursuant to a warrant, the truck was still at the truck stop. It is unclear where the truck was when Mr. Feltman went and retrieved the cell phone. So as standing as an issue that the burden is on the defendant, I think that it would be incumbent on the defendant to establish the facts that you just outlined. In the absence of such fact, and the fact that Mr. Feltman was able to readily go to the truck and retrieve the cell phone, because of that, that it's not overly clear where the truck was at that point. I think it's the defendant's burden to establish that.
But what if, okay, so let's assume for the sake of argument, then it's still out at the truck stop, all right? And assume they met that burden, although I don't know that they have. Then does that make a difference, is my point, that the police were the ones who said, please go out to your vehicle and exercise control over it, you know?
I don't think
Would it make a difference in a hotel, for example, if the police were the ones who said, hey, we think you should evict this guy, so that they could then go inside and check it out?
I don't think so. I think that goes to the reasonableness of the expectation. In Tillman and in some of the cases that were cited in Tillman, the part of the expectation of privacy and the reason that the expectation of privacy was no longer reasonable was because the individuals were engaged in activities that would reasonably lead to an eviction. Or that they should have known that they were, subject to eviction due to whether it's loud noise or the smell of marijuana, which was in the Tillman case. And so I think in this case, Mr. King, knowing that he was arrested and incarcerated, knew or should have known that his employer was going to regain control of his vehicle. The trial court pointed that out at the suppression hearing, that Mr. King knew that this was not his vehicle. He knew that it was, when he was arrested, it was going to be given back to someone with a greater property interest in it. So I think that goes to the reasonableness of his expectation.
Yeah, but isn't part of Mr. King's job entails him sleeping in this truck, right?
It does, yes.
I mean, let's say Mr. King gets arrested and pretend we're on TV and you get your one phone call and he calls his employer and says, hey, I'm completely innocent. Please don't get rid of my stuff. Does he retain a property? Does he retain an expectation of privacy if he calls his employer and says, look, please don't do anything with my stuff. I plan on coming back to work at some point. does he retain an expectation of privacy if he does that?
I think he would have a better case for that. Yes, I think the record in this case is completely void of any relationship between Mr. King and Mr. Feldman, whether there was an employee-employee contract. That might change the situation as well. But the record that we have here is just a standard employee-employee relationship, which is at will, which would give Mr. Feldman the right to do whatever he wants with his
So does that
property.
turn on Oklahoma law, what their employer-employee relationship is?
That's
Like if we're in Michigan and it's a union state, does that, and I don't want to take up
see
too much
that
of
I'm
your
out of
but-
time.
Okay,
You can
I'll let
answer
it
the
go.
question.
Would you like it answered?
No, I'll let it go, don't worry.
Okay. Thank you.
Thank you, counsel.
Good morning. I'm Mary Thornton. I am from Fort Worth, Tarrant County, Texas, and obviously I represent Terry King in this case. If I could, because of the court's questions, I would like to give a couple of dates, several dates actually, because I think the dates in this argument are extremely important. This offense occurred in April of 2018, and Terry was arrested at a truck stop on July the 17th of 2018. I believe it was Judge McClure that asked about the time of the warrant, or somebody asked about the time of the warrant. It is in the record, and in Oklahoma law, when they get a search warrant, you have 10 days in order to execute that search warrant, get your inventory, and return. I would have to assume, and I believe that is also in the record, that that first day doesn't count. So he was arrested on July the 17th at that truck stop, and then they immediately, the Oklahoma police immediately procured that search warrant. The truck was searched. You will read in the Court of Appeals opinion, they are under the impression, or they put in their opinion, that the cell phone, and it was photographed, that's in the record, but they are under the impression that that phone was not in the inventory and return, and actually it was. If you look at Defense Exhibit number 7, I
Hurt your
believe Ms.
case?
Oblon.
Doesn't that hurt your case then? If it's in the inventory, why can't the police just go in and say, well, we inventoried this, we said we were gonna seize it, it's justified by the warrant, we can just seize it? We can just go back and get it, because it's supposed to have been seized?
You know, Your Honor, in preparing for this and writing this argument, I've thought about that many times myself. But actually, I think it helps Terry, because in this particular situation, it's the police's fault. It was their sloppy behavior. It's their sloppy conduct.
Well, you would agree, though, that the warrant itself, the initial warrant, would have provided a justification to seize that phone?
Absolutely, sir.
Okay.
I would. Yes, the warrant, and that's why, obviously, we have a Fourth Amendment, because you've got to get a search warrant. And you've got to execute that search warrant under Oklahoma law within 10 days.
Yeah,
And
counsel, your whole argument is based upon the reasonable expectation of privacy, correct?
yes, ma'am.
Are you aware of the line of federal cases that say in the commercial trucking industry, there is, because of the nature and perversity of the regulations the commercial trucking industry is subject to, that there's a minimal expectation of privacy in a commercial trucking vehicle?
I would say there's a minimum expectation of privacy perhaps in the cargo, because you can search that cargo, you can search that, what do they call it, the trailer. But in terms of the tractor, in terms of the cab, I believe the word is, that person has an expectation of privacy because he's actually living out of that truck.
Well, according to the federal case law that I've read, that even if they sleep in the truck, there's a minimal expectation of privacy based upon the nature of the regulations that the commercial trucking industry is subject to.
These are personal belongings, though, Your Honor.
Well, I understand that, but
I mean, we're talking clothes, you're talking toiletries, you're talking prescription medication.
Well, counsel, minimal expectation doesn't mean no expectation. But my question, though, is why is it, given the low expectation of privacy in the cab of a truck, you couldn't just say that he has sort of assumed the risk and maybe even abandoned his phone in that truck?
Well, and to answer that question, Your Honor, as a trial attorney, I wish that this record had been better developed. I believe it was Judge McClure that started talking or asking questions about whether Terry had been fired or whether he'd been terminated, which I think would be very important in this case.
But it's your burden, right? It's your burden to show standing. So it's like to complain about the record when it's the defense's burden to show standing is kind of
Well,
purpose for you.
and Judge, you're absolutely correct. It is our burden to show standing. However, had Mr. Feltman testified, we would have at least known whether Terry had been terminated or whether Terry had been fired or whether he had hired another employee to use that truck. But I will say this. As I said, the search occurred on the 17th. On the 24th, the return came. And then in between that time, from the 24th all the way to August the 9th of 2018, we know that that truck sat somewhere. It was at some point before August the 9th that Detective Hines called Mr. Feltman and said, look in that truck. I think we can draw a couple of conclusions about that, or at least inferences from that. Since he was able to look right in that truck, I think it's reasonable to assume that he hadn't hired somebody else, that he hadn't fired Terry. Recall also that Terry was in jail. Terry has been incarcerated since July the 17th. Whether Terry could have called somebody, whether Terry could have called, I think that's a misplaced.
So counsel, let me just make sure I understand. If your argument is you sort of agree with and conceptually with the state that if there's no expectation of privacy in this truck, then the warrantless seizure of the phone is perfectly fine. But if there's an
Correct.
expectation of privacy, then you can challenge the search. But if there's no expectation of privacy, the seizure of the phone's fine.
Yes, sir.
Okay.
And I believe the cases that we've cited in our brief, we even went outside the jurisdiction. I believe one came from Connecticut, one was a federal case. But it talked about how when people were where they were supposed to be, but for whatever reason, the police came and arrested them, and they were under arrest, which is state action, then they can't assert, they can't call, they can't say, oh, seize my property. They can't, they can't call the employer and say, I'm in jail, please seize the property. And I also wanted to point out, the August the 9th date, you're talking about approximately 3 weeks. We know the warrant was stale, but I would submit, and I think we can infer from this, that, Mr. Feltman had not fired Terry. I think we can draw that inference.
Was the truck sitting there the whole time?
I'm sorry, sir?
Was the truck sitting there the whole time at the truck stop, or did they tow it somewhere?
I'm assuming it went somewhere, sir. I'm assuming it went back to the owner of the trucking company, Mr. Feltman, because when the detective called him,
that's right.
he was able to look right in the truck.
Yeah, that's right.
So,
Why wouldn't law enforcement have the right to just do an inventory of the vehicle once they arrested the guy without a warrant?
we had a case on that in the brief. Even an inventory search has rules. And in this particular case, I think the whole key and the crux to this case is you've got the Fourth Amendment. The Fourth Amendment says you need a warrant. The cops had their opportunity. This was not a theft case. This was, good heavens, an injury to a child case. This was a major case. And the cops were sloppy.
I'm kind of stuck on something, though. I'm wondering if you can help me over it. I know that the ground of review that we granted in this case has to do with the expectation of privacy, right? But what if something overrides that? What if, for example, the fact that there's an automobile, which I don't know that you're contesting that that's what this is, and that there's probable cause to believe that there's evidence in that vehicle that may pertain to a crime, why can't the police go in there and just search it? Why couldn't we reach that without overstepping the ground of review that we granted here? And are we authorized to do that?
Well, I think several of the cases, Betts comes to mind, several of the cases that I've read that we've cited in the brief, I believe a few the state cited in the brief, but it says, yes, no, the police can't do that. You do have an expectation of privacy. When you're driving, even a rent car that you don't rent, but say your girlfriend or your wife rented it, and only your wife can drive it, but you're driving it, and your wife gives you permission to drive it.
Yeah, but I think you're missing the import of my question. Does the expectation of privacy that someone has in their own vehicle even override the automobile exception once police have probable cause?
If they get a warrant.
Okay, thank you.
I believe you have to have a warrant.
I'm sorry, isn't that backwards? The real question is just, is there an expectation of privacy that gives rise to the ability to challenge a search? If there's no expectation of privacy, then you have no standing and you can't really complain about the search. But then the next step is if there is an expectation of privacy, is the search justified? And we're not here to answer whether the search is justified. We're here to answer whether or not the police or an agent or anybody or someone walking down the street could just go into that truck and you could challenge.
This was a truck, and it certainly, the facts are set out by the Court of Appeals, the facts are set out in the state's brief as well. Certainly, this was a truck that was assigned to Terry.
Sure.
He was employed by the trucking company, Mr. Feltman. We know that with commercial truck drivers, and I believe somebody asked the question, it is in the warrant, this is a tractor trailer, it's an 18-wheeler. They live out of these vehicles. You go long hauling on the road and you're gone for days at a time, maybe weeks at a time. You're living out of this. I think the state wanted to make an analogy in its brief and it cites cases that talk about this being like a rental car.
Right, but why isn't this just like the situation where you have Antigua, where it's like, yeah, this guy lived out of all this stuff, just like you might live out of a hotel. But this guy gets arrested and the truck, which doesn't belong to this defendant, goes back to the owner of the truck. Why is it that any of the stuff that's left there, he has an expectation of privacy in that stuff that was left there when he's now basically been just kicked out of this hotel room that he's been staying in?
But Terry wasn't kicked out of a hotel room here, and Terry wasn't fired. Terry wasn't
He
terminated.
was just given
to
a
be
different
considered.
kind of hotel room.
Exactly, but Terry was incarcerated.
Right.
Terry didn't have an opportunity. I mean, I think the fact that the state says that, oh, well, he could call somebody or he could do somebody, I don't think that's relevant to this. I think the fact he's arrested under state action, the state arrested him. There's nothing he could do about that. There was nowhere he could go. And he's been incarcerated since July the 7th of 2018.
But counsel, the only authority that he had to be in that vehicle was given to him by his employer who owned the vehicle. So that was the authority and his ability to be in that vehicle to begin with.
Yes, Your Honor, but certainly, and again, if we did have a little bit better record, we could look at the employment contract, because I'm sure in the employment contract it's got somewhere. But when he is assigned to this truck, you can certainly infer that he can keep other people out. You can certainly infer that Mr. Feltman couldn't say, oh, well, just go on into Terry's truck and get something out of it. So he had that possessory right of that truck. Again, I liken this more to an apartment, or maybe to if you rent some RV for a year and go out with your family, obviously you're living in it, you've got all of your personal property, you've got your prescription meds, you've got everything in it.
But in those cases, you're doing the renting, you're paying someone to use the vehicle, and in this case, Mr. King was being paid to serve a job for another person
Yes,
using
ma'am.
the other person's equipment.
Yes, ma'am. But again, he has a possessory interest in the vehicle in the sense that he can exclude others from it.
But he can't exclude his employer from it.
Does he still really have a possessory interest if he's been arrested?
I would say all the more that he's been arrested, Your Honor, because the fact that he's been arrested, that's a state action. Where can he go? He obviously couldn't post bond because he remained in jail.
So does it make a difference why he was not able to return to work? Like, let's say instead of being arrested, he's walking in the truck stop parking lot and he trips and breaks his ankle and he's in the hospital for 2 weeks. Like, I mean, does that matter? Does it matter why he can't get back to the truck?
I would say with what Ms. Oblon said, yes, I think that would matter. In all of the cases that we cite in our brief, it specifically states that everyone that had that expectation of privacy afterwards, that person was under arrest or there was some sort of state action there. But yes, I would distinguish that. But in this case, you've got somebody who's incarcerated. Really,
Like what happens in a hotel room or someplace where somebody's living for a month or two, they're paying the rent or whatever it is, they get arrested, they're put in jail, and there's materials left in that room. Doesn't the owner of the hotel have the right to go into that hotel room and clear it out and get those personal belongings and do whatever he wants with them?
Well,
Whether it's at the request of state agency or not?
Your Honor, I believe there are a couple of cases in the brief, the Fogg case, Connecticut. There was another case in there that we've cited in the brief, and it specifically talks about that. One was, very briefly, the guy he was paroled, he had rented an apartment, and he paid a month's rent, and within that month's rent time, he gets arrested, and the police go in and search it pursuant to a warrant on a murder. They think he committed a murder, so they go in and search it. Well, then they get it, they miss everything. They get another tip, oh, well, the decedent's cell phone's in the wall. So then they go into the apartment. I think it's 5 days after this person should have, I think Mr. Fogg should have paid rent, and they go into that apartment and search, and the Supreme Court of Connecticut, I think if I've got the correct case, it's in the brief, states that no, he had a reasonable expectation of privacy. He hadn't been evicted from that room, from that apartment. And they actually had a record. They had called the owner or the manager of the place, and the manager said, sure, and he come out and, paid $450 in rent. Sure, he could stay there. They declared that he did have a
Right, but
possessory
that's where he
interest.
has a possessory interest in it. And it's Connecticut law too, wherever it is.
Yeah.
But I'm just saying, this is a truck he doesn't even own, and it's left at a truck stop where it's subject to being towed, or the owner can call somebody and say, bring it back to our business because we're concerned about anything that might happen to it. This guy's just driving the truck, and he's paid to do it, and he has his personal belongings in it, but he's no longer there.
But Judge, I believe he was arrested. He was at the truck stop with the truck.
Right.
It was a truck.
Right, but once he was arrested, the truck was there, unoccupied, perhaps illegally parked, whatever. Certainly, the owner has the right to say, look, I want that truck back in my business, in my state.
And had that been developed, maybe the owner might have said, well, this is a consensual search, but that owner wasn't called.
Can the owner, let's put it, take it out of the context of law enforcement. This guy gets arrested and he's left his personal property inside the truck. Can the owner then just sell all of the guy's stuff?
Well, if it were my truck and I left something valuable in there and the owner sold it, I'd certainly want to file a lawsuit on that.
Okay.
I would consider that my property. And I was rightfully in that truck, and I'm working for, and I'm making money for that owner, I have to presume. I'm assuming he's making money. He owns a trucking company. So I sure do think I have a possessory interest in that truck. Yes, sir, I do.
I don't think you'd have a possessory interest, but you might have a property.
A property, and I certainly have an expectation of privacy, and I'd certainly have the right to complain, yes.
Well, once a warrant to search that truck has been executed, they've searched it, they've crawled all over it. How reasonable is that expectation of privacy at that point, given that he never retakes possession of it?
Well, he had expectation of privacy at the time of the search with the warrant because they got a warrant.
But after that point, after they've already searched it, doesn't that impact the reasonableness of any expectation of privacy?
Terry doesn't think so, Your Honor.
Does it make any difference
No.
that
course it doesn't.
what happened here with regard to the retrieval of that phone wasn't actually itself a search, but instead a seizure?
It's a seizure.
Yeah, so does that make any difference to any of this analysis?
Well, that's what we're arguing. It's the seizure of the phone. They got a warrant to search that phone.
Right.
So we're not arguing that. There was a valid warrant to search that phone, but they had the phone illegally. And the whole point of all of this is they could have had it legally.
See, that's the thing. I'd asked you earlier, and I've asked this question a couple times now. If there's no expectation in of privacy in the place searched, you've said, like, if we determine there's no expectation of privacy, then it's over and they can get that phone. But now you're saying the seizure of the phone is different than the search of the place.
Oh, no, the search of the phone, sir.
Search of the phone.
Yes, sir. They got a warrant for the search of the phone.
Right, they did. But my point is that we're here to determine whether there's an expectation of privacy in the truck. If we say there's no expectation of privacy in the truck, does that pretty much decide whether or not the police were capable of seizing anything that they found in there?
Yes.
Okay.
I believe that, I mean,
So
this
there's
whole
not really a
point-
distinction between search and seizure here. It's just, if
It's
they
the
could search the residence, they could get the phone.
It's the question of whether Terry has standing to complain.
Right.
And obviously, he has a subjective concept of privacy, and we believe,
Sure, he's got a subjective expectation of privacy in his phone, but in the seizure of, in the contents of his phone or what have you, and maybe he thinks he has a subjective interest in possessing his phone. But whether that's objectively reasonable, especially if we say that there's no expectation of privacy in the area where the phone was, seems pretty hard pull.
well, again, we believe it's an expectation of privacy that would be accepted by the public.
But there's a difference between an expectation of privacy and an expectation of the right to possess something, a possessory right versus a privacy right. And so
I
this
suppose
is,
so.
I think this may be an important distinction, and I wonder if we need to be careful about observing what we're talking about here. Are we really concerned about his property right, or are we really concerned about his privacy right?
Well, in this situation, I think it's both. He has the expectation, and it's his property.
Just to build on that, counsel, is there any line of cases that say a person has standing if their privacy or their property rights are affected?
Now, I would, again, you're talking about privacy, expectation of privacy and including personal property.
We typically focus on expectation of privacy. I'm a big
Yes.
fan of the expectation of privacy test, but it doesn't change the fact that there have been some cases that say, look, if you're interfering with property rights, that can also be a search, or that can also be some sort of justiciable interest in challenging a seizure.
I suppose so, but I agree with you. I do think the issue in this case was the expectation of privacy and whether he had standing to contest that charge. And yeah, I think he has a property right to his phone. Yes, I do.
Okay.
Thank you.
Thank you, counsel.
Just a brief rebuttal. I'd like to start by again pointing out, and I think it's rather clear, that standing is an issue that the defense has the burden on. To distinguish some of the cases that my opposing counsel relied on in her brief, that the Connecticut versus Jacques case, when the court was looking at the reasonable expectation of privacy, they looked at the property laws of Connecticut. There was a lot of testimony regarding the relationship between the renter and the apartment manager in that case, developing that relationship between the two, the fact that the defendant there, he had all of his possessions there. It really was his home. And the court looked at, again, that the property laws would have allowed him to return to his apartment even after being late in his rent. And that allowed the defendant there to meet his burden, because the court looked at the mere existence of those property laws, established that society recognizes a reasonable expectation of privacy as long as the eviction has not happened. There is no similar employer-employee laws here in Texas, and I don't believe there are in Oklahoma either. I'm not entirely sure, but if we were to apply Oklahoma, I believe it's at will as well. That would dictate what society is willing to view as reasonable. And I think, Judge Keel, I think you pointed out a very good issue that might have went missed in my briefing as well as opposing counsel. Once that search warrant was executed, that in and of itself, along with Mr. Feltman coming in and regaining possession and control, really diminished, if not completely evaporated, Mr. King's expectation of privacy in the truck at that time.
Well, counsel, the flip side of that argument, though, is once you get a warrant, does that mean you never have to get another warrant? I mean, there's a statutory provision that specifically creates additional requirements for a second warrant on a particular place. So
that is true. That is true. I think that it would diminish it, and it just goes into the overall. When we're looking at any Fourth Amendment issue, we looked at the totality of the circumstances.
objectively.
Yeah, objectively. And in this case, there is simply no evidence of an employer-employee relationship, of any additional expectation of privacy that Mr. King had in this specific truck. As Judge Slaughter, you pointed out, there is a diminished expectation of privacy in commercial truckings to begin with. And once Mr. Feltman regained possession and control of that truck, Mr. King's expectation of privacy was extinguished, and therefore Mr. Feltman entering the truck to retrieve the cell phone was not a violation of Mr. King's Fourth Amendment expectation of privacy.
With regard to his expectation of privacy, though, the police had already conducted a search inside that vehicle, and they'd taken some photographs, one of which showed that the phone was in the vehicle.
Yes.
And they had actually included in their list of items that they took the phone, even though they didn't take it.
Yes.
So they knew the phone was in the vehicle. I mean, And I'm wondering, what interest is a privacy interest designed to protect but knowledge of what's behind the window, right, or the closed door? And if the police already know that, with regard to that phone, it's really, it's not private anymore, if that makes sense, If a fleeing suspect runs into the door of a home and there's no other exits but that door, they know the suspect is in the home. It's not really, that's not something that is defended by the privacy that you have in the home. Everybody already knows that. So I wonder if you could speak to that for just a moment.
Again, I think that goes to the totality of the circumstances in looking at it. If police already knew that it was there, would society then recognize an expectation of privacy in that phone? I think the answer is no. And then coupled with the lack of relationship evidence between the employer and employee, and the fact that Mr. Feltman had already regained control and possession of the truck, Mr. King simply did not have standing and did not prove that he had standing in the trial court. And for that reason, we asked this court to affirm the trial court's ruling.
Quick question.
Yes.
If someone is arrested in an Uber, and he's got his property on the seat, and he's arrested, and his phone is there and some other things, does he lose his privacy interest in that property the second he steps out of the car?
In the property itself?
His phone that he left on the seat of the Uber.
Well, I think, again, there's this distinction between the contents of a cell phone and of the purse, or if it was a female, if it was a purse. I think that there would still be that expectation of privacy in the contents of any items. But if he is arrested, and whether if he leaves the items, he or she leaves the items in the Uber could drive off. And so I think that it would kind of depend on what the Uber driver did with the vehicle at that point.
Thank you.
I have a quick question. Does it make a difference, or is there any distinction between the fact that this is a personal belonging versus contraband?
I don't think so.
Okay.
No. Thank you. We ask you to affirm the trial court's ruling. Thank you.
Call now, cause number PD-0239-22, Andrew Shirley Jr. versus the State of Texas.